Good afternoon, everyone. Welcome in. Hope you've enjoyed your lunch and your fellowship. My name is Michael Kaufman, and I have the incredible joy and privilege of serving as the dean of this wonderful law school. I'm actually the 16th dean in 114-year history of this law school. And so, following the meme, it started really well 114 years ago, and it's going great now. Welcome, one and all. You may know that for 114 years, we've had a very long and strong tradition here at the law school. We've been beginning every special occasion and marking the occasion along the road with expressions of our collective gratitude. And you can already tell this is a really special occasion. It's been an incredible morning so far. We look forward to an incredible dialogue in a few moments and this afternoon as well. So let's begin this part of the occasion by marking this gathering with gratitude. First of all, I want to thank on our behalf the incredible Mita Datta, who is with us today. You may have recognized Mita. Mita Datta is the name on the Datta Center for High-Tech Law. Recently, Mita named the center after her parents, wonderful educators from India. Mita is with us today, and I think it's fair to say that she has been the inspiration, the support, and the heart and soul of this center. So thank you, Mita, so much for all you've done for us. Thank you so much. I want to thank as well on behalf of the incredible members, the team of the Datta Center. People who greeted you today, they are Doris McDonald and Joanna Justus, who are outside. They greeted you this morning, and when you leave today or you go back to get some more food, please take a moment and thank them on our behalf as well. They're wonderful. Thanks as well to the incredible colleagues of the Datta Center who you've heard from today. Tyler Ochoa, you're going to hear in a moment from Ed Lee. Zahar Saeed is here with us. Eric Goldman is here. I saw our former colleague, Colleen Chin, who is with us. Thank you for coming back. Always a member of our family. Thank you for being here. Who else? Emily Burns is here. Brian Love, you've heard from already. And I think I've spotted everybody. But they're incredible scholars, educators, and public servants as well. Thank you all so much for your vision to make this happen. And I want to thank always on your behalf the people who prepared the food that we are enjoying today, who grew it, who harvested it, who prepared it for us and served it to us so well. We always thank them. And then I want to thank, of course, our wonderful guest speakers. First, Paul Grewal, a real friend of this law school. Thanks for coming back, Paul. Paul's magistrate judge was and is now, of course, the chief legal officer of Coinbase. Thank you so much for leading our dialogue with Judge Alsup. And we are truly blessed to be joined in conversation today in a fireside chat with the incredible Judge William Alsup, who since 1999 served on the bench of the Northern District of California. And in the meme of how it started and how it's going, you may remember that in 1999, the number one song in the country was Cher's Believe. It's true. And now, I looked at it this morning, now the number one song is Die With a Smile. So I think I'm not sure. So it was great to have you here. As you all know, and Ed Lee will share more details about their biographies in a moment, but from my point of view, Judge Alsup really incarnates our mission of leading our students from knowledge to wisdom. He is an incredibly revered jurist, a brilliant intellect, incredible judicial temperament, great fairness, great attention to detail, an amazing public servant for all of his professional life, but also someone who really understands in a profound way the doctrine, the text of the statutes and the cases, is attentive to detail. That's the knowledge part, right? And knows about technology as well, but also really embodies wisdom. And we're trying here in the law school with the help of the Datta Center to get our students to go from knowledge to wisdom. Wisdom, as you know, is the practical application of knowledge to evolving circumstances, always with an eye toward human flourishing. And Judge, you incarnate that vision of knowledge to wisdom. It's great to have you here. And so let's join me in welcoming our great guest. Thank you so much. And now I'm going to turn it back over to Ed Lee, our wonderful colleague, who's going to do a more formal introduction and lead our panel. Thanks so much.
Thank you, Michael. Okay, I have the great privilege of introducing our special program to celebrate our guest of honor, Judge William Alsup. Now, it's a daunting task to introduce a judge who really needs no introduction, especially in this vast community of legal scholars, law students, and lawyers in the heart of Silicon Valley, including many of Judge Alsup's law clerks. Judge Alsup is, in a word, legendary. But please indulge me for a few minutes as I try to convey at least some of the accomplishments that have made Judge Alsup one of the most influential and important jurists in this country for the past 26 years. Now, consistent with this conference's theme, let's start with how it started. For Judge Alsup, it started in Jackson, Mississippi. Judge Alsup grew up during segregation in the Jim Crow era. But as he movingly described in his memoir, Went Over, Judge Alsup joined the civil rights movement as a college student, including participating in protests and helping to organize a student on-campus event in 1967, hosting the first black speaker to speak at Mississippi State or any other white college in Mississippi. That speaker was Aaron Henry, a pharmacist, civil rights leader, and president of the state's NAACP chapter. With his friends in the same Young Democrats student group, Judge Alsup hosted Mr. Henry's talk on campus. But that was no small feat back then during the height of segregation. The university had a policy banning any speaker it deemed to be too controversial or dangerous. This policy was basically a way to keep civil rights advocates away. So the university, not surprisingly, denied the students' request to invite Mr. Henry to speak on campus. But Judge Alsup and his friends persisted. They wrote a protest letter to the university president, which was published in the school newspaper, and received further support from a faculty protest letter. But the letters prompted no change by the university. So what did Judge Alsup and his college friends do? Well, I think you can guess. Yes, they decided to file a lawsuit against the university. They even found a lawyer willing to represent them pro bono, along with receiving advice from the ACLU about their First Amendment rights. Judge Alsup then wrote a letter to the university president carefully explaining their reasons for filing this lawsuit. That letter and the threat of a lawsuit are what convinced the Board of Trustees of the university to reverse their decision. So even before a lawsuit was filed, the university allowed Mr. Henry to speak on campus about the passage of the Voting Rights Act before 800 students on campus, a historic event. Now, the lesson of this and other peaceful protests during the civil rights movement are still relevant, especially today, when many people, including students at this university, are engaged in a national shutdown to protest the brutal tactics of ICE. What Judge Alsup wrote back in 1967 as a college student still resounds today. They were protesting because they sought, quote, to further the task of living with and not against our fellow citizens, unquote. Judge Alsup's involvement in the civil rights movement during college was formative. It was one of the experiences that led Judge Alsup to switch his studies and career goal from engineering to the law. Now, in the interest of time, since we are short on time, let's turn to how it's going and Judge Alsup's legal career. Judge Alsup received his law degree from Harvard Law School and a Master of Public Policy from the Kennedy School of Government. He clerked for Justice William Douglas on the Supreme Court, and then in between stints working as a highly accomplished trial attorney at Morrison & Foerster in San Francisco, he was an assistant to the U.S. Solicitor General arguing cases before the Supreme Court. As we heard, in 1999, Judge Alsup was appointed and confirmed as a federal district court judge here in the Northern District of California. And I would have to say we are all better for it. During the past 26 years, Judge Alsup has written thousands of opinions and orders in cases of great complexity and significance. His decisions have in turn been cited by other courts thousands of times. Now, that's every law professor's dream, so some tips from Judge Alsup. Judge Alsup has presided over and decided some of the most important cases for this country. Now, for those of us at this IP conference, we are, of course, most familiar with his decisions related to law and technology. Arts versus Anthropic, Google versus Oracle, Waymo versus Uber, Sonos versus Google, to name a few. But Judge Alsup's impact is far and wide in many areas of law. He has issued important opinions and lawsuits related to the class action challenge to the government's recent termination of federal employees, the government's termination of the Deferred Action for Childhood Arrivals, or DACA program, PG&E's criminal probation for its role in the 2010 wildfires, a class action to challenge the government's process for student loan forgiveness, and even the contempt proceedings against the former trainer of Barry Bonds in the Balco scandal. Now, I should add one more case. He presided over a class action antitrust lawsuit involving NVIDIA in 2007, before NVIDIA became the AI chip juggernaut that it is today. These cases had great significance, not only for the parties, but for this country. Now, I think everyone who has read a Judge Alsup opinion will agree. They are clear, crystal clear. In a recent profile in Bloomberg Law, Judge Alsup, who is a highly accomplished photographer, has likened the process of writing a judicial opinion to taking a photograph with careful framing, sharp focus, and the ability to find and isolate a strong, clear subject. Judge Alsup's opinions are also literary, often containing a memorable line or arresting phrase, words that pack a punch. Of course, his opinions are also exceedingly careful and meticulous on the facts and the law, with an uncompromising attention to detail, much like an engineer would devote. And they are incredibly insightful, and typically they are correct as a matter of law upon review by the appellate courts. Consider an example from copyright law. Those who study and practice in copyright law, including myself, all know that Judge Alsup's rulings on fair use in Google versus Oracle was ultimately vindicated by the U.S. Supreme Court. But what few of us may realize is that Judge Alsup's same ruling was vindicated not once, but twice by the Supreme Court in the court's later ruling in Andy Warhol Foundation versus Goldsmith. In 2016, Judge Alsup ruled in Oracle, I'm quoting, "One use might be a fair use, but another use might not, and the four statutory factors are to be applied on a use-by-use basis." The judge then quoted Section 107 in support. Judge Alsup's opinion is the first federal decision interpreting the 1976 Copyright Act that clearly stated that the fair use analysis must be conducted on a quote-unquote use-by-use basis. 7 years later, in the Warhol case, the Supreme Court adopted the same use-by-use approach, saying it requires an analysis of the specific use of a copyrighted work, and the same copying may be fair when used for one purpose but not another. Eerily reminiscent of what Judge Alsup had said 7 years before. Now, several scholars in the room, including myself, have recently written about the Warhol case, but who knew we could have written our articles back in 2016 after Judge Alsup's decision in Oracle. This example is emblematic of Judge Alsup's decisions, drawing legal insights that escape the attention of most others, and in doing so in a way that is clear and laser-focused. As Judge Alsup put it in an interview, one sentence can be worth pages. Now, to parties and lawyers who appear before him, Judge Alsup is known as a tough, and I will underline that as tough, but fair judge who is committed to equal treatment, fairness, and decency. Indeed, these principles that guided Judge Alsup's participation in the civil rights movement as a college student, and they are the principles that thread all of Judge Alsup's decisions, even to his last decisions handed down last month. In one of them, Judge Alsup ordered changes to a class action website because it did not afford, quote unquote, equal dignity to the choice of those class members who elected to opt out of the class settlement. With his characteristic attention to detail, Judge Alsup basically went line by line over the website and redesigned parts of the website to ensure it gave equal dignity to all class members. Incredible. Now, respecting the equal dignity of all individuals is an enduring lesson that we can all learn from Judge Alsup. To sum up his tenure as a federal judge, I will take the liberty of borrowing his own words from a recent decision that many of us know well. While the judge was referring to the technology of AI, please allow me this poetic license when I say Judge Alsup is one of the most transformative judges many of us will see in our lifetimes. But enough speaking by me. You came to hear the judge. It is now my distinct honor to turn things over to the Honorable Paul Gruel, former magistrate judge here in the Northern District of California, former deputy general counsel of Facebook, and now the chief legal officer of Coinbase. As Michael has said, Paul has been a trusted advisor to Santa Clara Law School for many years. And if you witnessed him testifying before Congress or being interviewed on national TV, you know there is no better person in this country to lead today's fireside chat than Paul Gruel. Take it away.
Thank you very much, and thank you all for joining me in this incredible opportunity to thank and get to reminisce a bit on the career of one of the most impressive federal judges this country has ever seen. I have the daunting task of attempting to lead a discussion covering a career that spans William Douglas to training and inference models, all in under 30 minutes. And so here we go. Judge Alsup, it's a pleasure.
Thank you. My pleasure.
I want to actually start in Mississippi. We're going to talk about the IP work that you've done over many decades and your influence, but I want to go back to Mississippi. In your memoir that Professor Lee alluded to, you spoke of the influence of your parents on your sense of decency and integrity and in the work that you did on the bench and in the law. Could you just share with the audience to start, what role did your parents have and how you thought about the fairness part of judging?
I'll answer that. I want to thank Professor Lee for the nicest thing anyone's ever said about me. So thank you. I grew up in Mississippi. My mom and dad, of course, were white, and it was at the time of segregation was the law of the land in Mississippi. So you younger people can't even imagine that there ever was such a time that by law there would be black schools, there would be white schools. And I could go down the line of all the segregation. My mom and dad were of two minds about segregation. They did believe, at least my dad did, in segregation in the schools. But curiously, he did not believe in that when it came to churches. In his view, everybody should go to any church they wanted, and God did not discriminate. In fact, he believed that so strongly that when they changed the preacher out, and this was in the 50s, whenever Brown v. Board had just come down, when they changed the preacher out at our church, Presbyterian church, to bring in a segregationist preacher, and got rid of the prior one who said, like my dad thought, everyone should be welcomed at any church. And so my dad quit the church. It was his way of protesting. Now, switch gears for just a second. Growing up alongside that whole regime, every one of you had a mom and a dad, or at least one of them, and I know what they taught you. They taught you to be fair to your brothers and sisters, be fair to your friends, don't lie, all those basic things, decent, be decent. Well, that's the way they taught us, my mom and dad. And part of that was even that never use the N word, because that was not decent. So we had these two regimes growing up in parallel. Segregation on the one hand, which at least in the schools my dad definitely agreed with. And on the other side, decency and fairness. Well, at some point around high school, me and my friends, all white, of course, because we were segregated, we began to ask, they were all raised the same way, fairness, decency. Well, what is fair? You could look at blacks could not vote. Blacks could not go to the public library. Blacks could not attend the same schools, and the schools that they did attend were terrible. So we said, what's fair and what's decent about that? So now this had nothing to do really, this was not coming out of the Bible. It was not coming out of the law or the Supreme Court. It was coming about through homespun ways of life that you learned around the kitchen table, fairness and decency. But those were very important. And we took them to heart. And that was the motivating factor for me and my friends to say, there's something wrong with this system. Let me just stop there. But fairness and decency have always been a important, concept for me.
There had to be a better way. Well, I wanted to start there because when I had the privilege of serving far below Judge Alsup in the court, a lawyer wasn't very happy with one of my rulings. I suspect you've had this happen to you, Judge, once or twice. And he, in the hallway, I could hear him. He didn't know I could hear him. Insulted me. And the way that he insulted me was he said, that gray wall is just a wannabe Judge Alsup. To which I said, you're damn right. and I think you can see why.
One time I got a call like that. It was after I ruled against the dog in a case involving a dog. I got a voicemail saying, on my line at the court, criticizing me up and down, and it ended by saying, I cannot wait for the next election to vote against you.
Well, we are at an IP conference, Judge, so I do need to turn to a few IP topics. Professor Lee and others have summarized your incredible influence on so many different areas of intellectual property law. I want to ask you, in the realm of IP, is there one case, one decision, one trial that in your incredible career spanning many decades stands out as particularly memorable?
IP, you're limiting this to IP. Yeah, Oracle v. Google would be the number one. And in a single sentence, I was so convinced I was right. I had two trials. First trial goes up to the Federal Circuit, reversed. So I salute, come down. We have the second trial. I again rule in favor of, in this case, fair use. And it goes up to the Federal Circuit, reversed. So I said, I'm a good soldier, but the Supreme Court granted review. And Stephen Breyer wrote a wonderful opinion, totally vindicating Judge Alsup. Let me tell you, that doesn't happen too often. If it happens once in your career as a judge, you're lucky. And so that's the one that stands out. And not only because of that procedural history, but because it was an important issue of fair use.
Very important issue. Very important issue. A very memorable case for me as well, because, Judge, you may not remember this. You actually, when not long after you were assigned that case, sent it my way to try to settle it. And obviously I failed miserably in that task. But I'm glad at least it led to ultimate vindication in your case. Well, I focused on IP cases, but let me ask you a more general question, because I do think that for IP law students, practitioners, academics, there can be a sense sometimes that this is the universe that stands above all others. And of course, as a federal judge, you handle cases of all types and all stripes. Across all of your cases, going on 3+ decades of this, which case stands out in your mind more than any other?
Well, I knew the questions he was going to ask. So I have thought about this. The case that I feel, I'm going to give you two.
I think you've earned that right.
The one was the DACA case in 2018 when President Trump decided to end the DACA program. That's the Deferred Action on Childhood Arrivals case. And sometimes referred to as Dreamers. And so there was immediate lawsuits, maybe not all over the country, but I think three places in the U.S. And we got one filed by the University of California here. It got assigned to me, and we had a preliminary injunction hearing. Now, there was a long list of reasons given by the plaintiffs for why the new rule of vacating the program and ending the program should be set aside. Constitutional issues, statutory issues. Now, all of this is on a hurry-up basis. You remember how it was.
Of course.
You lawyers may not realize how hard, you're throwing hundreds of citations at us, hundreds. Facts that may or may not be supported by the record. All of this is on a hurry-up basis, and we have to sort it out and see how solid various things are. Anyway, I knew this, I should say, and you never know anything, but I had a strong feeling it would go to the Supreme Court. And I wanted to have an opinion that would be upheld by the Supreme Court. And that, in turn, meant that we had to have the Chief Justice. So I thought through the whole case of what would appeal to the Chief Justice. And I decided that it would be on the narrowest possible grounds, Administrative Procedure Act. That don't reach the constitutional issues, don't reach the issues of executive power. So that order never mentions President Trump. It mentions the agency, but not President Trump. And it goes up to the Ninth Circuit firm. I expected that, but it did not. And then it goes to the Supreme Court, as I did expect. And we won by one vote, and the Chief Justice went on our side. So we were sustained in that, on setting aside the new rule that ended the program. That was sustained by the Supreme. My decision was sustained by the Supreme Court, and to this day, the DACA program still exists and is still operating. So that's one. The other one, I would say, where I did a lot of good for the people of California was in the PG&E probation. PG&E was convicted. Thelton Henderson presided over the trial, convicted of filing false reports about the fire explosion in San Bruno. That was a long time ago. It took a long time for the trial. But then Thelton went off the court, and I took over the case for purposes of the probation. So I had it for 5 years. And then in the very first year, what happened? Those wine country fires, there were 19 of them. 19. And so they were under my supervision. And believe it or not, a probation officer or the probation judge has a lot of power to tell even a big company like PG&E what to do. So I made them file statements. They actually just gave me the same ones that they had given to the PUC. And I had an extern, whose name I'm going to think of in a minute. He had been an Air Force veteran. I said, go through all of these and tell me what you make out of it. Well, he came back and he said, if you read them carefully, 18 of the 19 wine country fires were started by PG&E. And the way this happens is when the wind blows, these power lines smack together. They're not insulated. They smack together. For an instant, there's a huge spark. The molten metal falls to the ground, catches the dry grass on fire, and it starts a fire. Now, when the winter rains come, it's not a problem because it is a different problem, but it's not a fire problem. But in the summer and in the fall, all the way up to as late as Thanksgiving, it's a big problem. So from that day on, I started calling in PG&E and learning how could it possibly be that PG&E was starting all these fires. Well, that continued for a long time. And I'll just give you one example of some of the things I told them they should do. And I said, you would be reckless if you don't. Some of them I ordered it. Some of them I just said, you'll be reckless if you don't. I know that they would be afraid of that word, reckless, because they'd get sued. So then one of them was the power shutoffs. You can thank me for the power shutoffs. Because I said, you should be doing this. You know when it's going to get windy, and it's going to be windy enough to cause a fire. You should shut down the power, tell people in advance so they can prepare. But you should not be running energized lines through those windstorms. Well, they did that, and that cut the number of fires down a lot. The first year they did it, 0 fires caused by distribution lines. They had one caused by a failure of a tower, but that was a different problem. It wasn't wind. The second, next year, 2019, there were a terrible fire, but it was because they had relaxed the criteria, and I made them. So every time they had fires, I called them in and I made them produce evidence, even put people on the stand. And I cross-examined them because the government did not do a good job on the examination. It did a perfunctory job. And I wanted to get to the bottom of it. I said, I'm the probation judge. So the guy called the Trouble Man was the one I remember from the Dixie fire. Anyway, if you look at the history since the probation ended in 2022, the record's much better now.
Yes.
You don't see as many fires started by PG&E. And I think some of that, I take a small amount of credit for bringing safety considerations into play for PG&E. There'd be some other cases, but those are two that I look back on and I think I'll remember for a long, long time.
Well, what I like about each of those examples, Judge, is it proves that one judge can make a difference. It really can. And in many ways, we think of the Supreme Court, of course, for obvious reasons, the most powerful part of our judiciary, but a single federal judge can make a huge difference. I think you illustrated that very well. I want to switch gears, though. We've got a lot of ground to cover, and my time is a-wasting. It's been said, I think even earlier this afternoon, that you are known for a certain ability to have a turn of phrase or a quote and an opinion that is memorable. I just want to give a couple of examples of this. There are thousands of these I could have drawn from. You have described the federal government's loan forgiveness process as disturbingly Kafkaesque. You threw out an expert report relying upon the Nash equilibrium in that Google Oracle case we were talking about, and wrote, "No jury could follow this Greek or testimony trying to explain it. The Nash bargaining solution would invite a miscarriage of justice by clothing a 50% assumption in an impenetrable facade of mathematics." Now, when you're sitting in chambers at 5:31 in the morning, many days, writing your opinions, are you thinking about the impact of those kinds of turns of phrase, or do they just reflect how Judge Bill Alsup thinks at 5:31 in the morning?
I should begin by saying that many times those phrases have gotten me in trouble. There have been a lot of headlines that say Alsup blasts. Fill in the blank, lawyer usually. Alsup blast lawyer. And so some of those phrases have gotten me in trouble. But there's one, let me tell you one story and then I'll try to answer your question. I try to think of what is the essence of the problem. And in a lot of ways it goes back to this fairness point. The case I'm thinking of was right after I started. It was around 2000, 2001. it was a drug case, and it was a sentencing for a drug. The defendant was in his mid-30s. He had lots of drugs, kilograms. No question he was going to go away for 80 to 90 months. And so we had the sentencing hearing. He pled guilty. They had the sentencing hearing, and so he was sentenced. And then the lawyer asked for special consideration. And the lawyer said, this young man, we want you to let him out for a few weeks before he reports to prison. Normally he would go into prison right then, or I can't remember if he was already in custody, but in any event, he should have gone in then under the statute. But the lawyer said, please let him out so that he could help his dad move from his home to a senior living place, because his dad was now in his 80s. And then there was an elderly man in the back of the only other person in the courtroom was this elderly man. And the lawyer said this man back here was one of the Tuskegee Airmen. So the Tuskegee Airmen, for you younger people, during World War II, Tuskegee, a black university college in Alabama, because the Army was segregated, set up a place to train black pilots. And they served in 1943, 44, and 45 in Europe, where they turned out to be the premier fighter pilots. So back in the courtroom, here is this elderly man. So I said, please come forward. He came forward. And I quizzed him for a minute. I said, is it true that you were one of the Tuskegee Airmen? He said, yes. And he told me a little bit about his service. And he was showing his age. It was clear he needed help to move out of his home and into the facility. And he wanted his son to help him do that. Now, the government was against it. The statute was against it. And the government was afraid he would flee because he was facing such a terrible long time in prison. So this is where I'm coming around to quotable quotes. This is one that's never gotten in the newspaper, but it's one that I am proud of because it just flashed into my mind what the essence of the problem was. So I said, referring to the Tuskegee Airmen, I said, this man did something good for his country, and now his country is going to do something good for him. So I let the son out. He did help his dad get into the facility. He reported on time to the prison. Everything went as smoothly as possible. And that was the reason I did it. It was big, and it didn't fit the statute, but it fit the equities of the situation so beautifully that I said, that's why I'm doing this.
One judge making a difference. Judge Alsup, switching gears yet again, you were, if not the first, certainly one of the first judges in the country to really take to heart the idea that we need to pass on to the next generation of lawyers opportunities in the courtroom to continue to refine the craft and refine the practice. Could you just talk a little bit about how you first thought about setting suggestive standards, if not orders, to law firms and senior lawyers to give those kinds of opportunities to junior attorneys?
Yeah, I never did order it. Maybe once in a while I got carried away and said, why don't you let this young lady do that? But it was a strong suggestion.
Can you all imagine trying to say to Judge Alsup, thank you, no, I'm actually going to go.
No, it was quite a number of times. Both big firms on both sides let a younger person argue. They had both agreed that they would do it, so it kind of worked out. I took this job and applied for this job because I believe in the system. I believe in the judicial system, and I felt I was a trial lawyer for a long time, that you got to learn. It's not easy to learn to be a good trial lawyer. And you have to do it to learn. It's not, you just have to do it a few times.
Can't read a book.
You can't read a book. It helps, but it's not the same. And so I came into the job feeling that for the good of this institution, of the system, the judicial system, the younger lawyers have to be brought along to train the next generation. Otherwise, we're going to wind up with a generation that cannot try a case properly. And then justice suffers. Really, it will be justice that suffers because it may be that the lawyer on the wrong side of justice is better than the one with good intentions on the right side. And so you need to train the next generation. I very strongly believe it. So from day one, my first law clerk's here somewhere. She and I worked this. We had this not standing order, but standing strong suggestion that they do that. And it's the same is true for depositions. At the final pretrial conferences, usually there would be 2 or 3 younger people back there. In my era, it would be 1 or 2 lawyers per side. In the last 20 years, it's been 8 lawyers on each side, and there's usually 2 or 3 that are young. So I say, how about that? Was she going to get to take a witness at trial? And sometimes they'd say yes, and then sometimes they would say, well, we're still working on it. We're going to try. I never did push too much further than that, but I wanted them to know I was looking to see, because that's a big deal to have your first witness in a federal court case. So there have been others who picked up on this, and I think judges today are more sensitive to the need. It's not just for the young people; it's for the institution, so that when the day comes that they have to try a case, they'll do an okay, at least an okay job.
Another example of one judge making a difference. It's so clear, even in this conversation, let alone the many years I've known you, that your love of trial, your love of the trial process has only grown stronger, if anything, with time. And I'm just curious, what is it about the adversarial trial process that you think is so inherent?
This is an easy one to answer. Cross-examination. Every part of the trial is important. Jury selection is important. Direct examination can be the most critical, but usually, and half the trials or more, it's the cross-examination where the truth comes out. And I love those moments because I don't know how many of you are practicing lawyers. I'm going to assume all of you are good ones. And some of the bad ones, they will obstruct the deposition. They interrupt. They literally tell the client what to say in the deposition. That phrase, if you know, then the answer is, I don't know. Next question, if you know, I don't know. So but at trial, the lawyer cannot do that. They have to suffer in silence. I even had a rule, no shuffling papers and no coughing, because that was another trick, that they would shuffle papers, start coughing to distract the jury. No, I said, you can't do that. So I would say during the trial, Mr. Graywall, why are you coughing so much? We cannot hear this excellent examination by so-and-so. And would you please go out in the hall, and if you're going to do that, and let you. So I would do that. And so you knew not to cough and hack. You sit there and suffer in silence while the other side is killing your client.
I also seem to recall you having a jar of cough drops at the ready.
No, a container, a packet. I would say to the clerk, give this to Mr. Graywall. He seems to need a cough drop. So then I would give the other side 5 more minutes. Go back over those questions again. I want to hear them. We didn't hear them clearly. So it's important. Cross-examination. And you know something, if you look around the world, there are not many other systems as good as ours. What country has cross-examination to this? In every case, you get cross-examination. Our system is the best in the world, without any question in my mind. best in the world for getting at the truth. Now, that's why, again, these young lawyers need the chance to cross-examine somebody because there's an art to it. Short questions. You figured out what the point is you're trying to make. You get them to agree with the short question to that. And not the IP lawyers. I got to tell you, you got to work on this because you have compound questions with 42 words and 13 assumptions. Don't do that. 8 to 12 words, 1 point. 8 to 12 words, 1 point. This sounds like crazy that I have to say this to you, but it's true. 8 to 12 words, 1 point, and then you get them to agree. And you know they got to agree because you have their affidavit where they said that and whenever they thought it would help them. I could go on with the other parts of trials that I feel are very important. Closing arguments are very important. And I love the moment comes when it happens several times in one trial. Whenever the lawyer, get to make your points, and they cannot interfere, and the jury is listening to every word of it. It's a golden moment. That's why I love trials, because it gets at the truth.
It's powerful. It's absolutely powerful. You mentioned the patent and IP bar. There has been a rumor from time to time that as many patent trials and cases as you've presided over, maybe you're not quite as fond of the patent cases as some of the other types of cases that you've had jurisdiction over. Is there something about the patent case or patent trial that you maybe found a little more frustrating?
It is true. I did not. The patent cases and the patent bar argued over everything, every document request, every interrogatory. There was so much stonewalling. I just despaired. I did find that if you set a trial date, and you say you're going to trial on December 2nd, get ready. That helped some. But they would try, the losing side always could figure they were going to lose. So they would come up with every excuse they could. And the lawyers that they put in there sometimes were good obstructionists, but they were not going to be good trial lawyers. They were not going to be good in front of the jury. So I despaired over the number of preliminary fights. All that having been said, there were quite a number of patent cases that were very legitimate, very important, and that even though they probably had some of those moments, the good lawyers never brought those kind of problems to the court. The good lawyers said, "Judge, we're going to try this case. We're ready." Both sides would say that, "We're ready," and you'd wind up with very little work for the judge to do prior to the pretrial conference. And then they would try the case fair and square on both sides. The jury would make a decision on it. That occasionally happened, but rarely. Usually it was fight over everything. And now, in the copyright area, I want to kind of say one other thing about patents. Patents, 40% of them are void initially, right out of the gate.
Only 40?
It could be more, but I am positive 40% should never have been granted. It is a situation where it's ex parte. There's nobody on the other side. The people have a right now to go in, but they don't want to do it. They want to save their powder for the district court, so they don't go in. And so the patent gets issued, and the wool is pulled over the eyes of the examiner, in my humble opinion. And then they come to the court. So 60% are valid. I'll give them 60%. But think about that, 40%. I gave a speech in Japan once. They were shocked to hear that a judge thought 40% were invalid. They thought 100% were valid, 40% invalid. So we have this system. I want to back up and say, in the pharmaceutical side, probably more are valid. I don't know. I'm going to say they are. But those of you who are from Silicon Valley and are more worried about the what would you call it, the electronics part, those are where 40% of those are invalid. And So what a system that we would have that we have to litigate. And the two things that bother me the most, it hurts competition and it hurts innovation. Because if you're a real innovator, let's say you're somebody that invents the iPhone. And by the way, thank God for Stephen Jobs and those video cameras that can now are on every street corner. And if the police do something bad, somebody is videoing it. That didn't happen in 2000.
You certainly didn't have those in Mississippi.
It did not happen then, but now every citizen can be a truth teller of videoing what happened. Thank God. But think about the iPhone. How many inventions are in there? How many engineering solutions are in there? I'm going to say 5,000, 10,000 inside one. But then one little thing, they come in and say, on a patent that's probably invalid to begin with, and say, okay, we want 1% of your, and they say to the jury, oh, just 1%. Just 1%. Well, they don't even. That's 100 times more than they would really deserve, and and yet it sounds so reasonable. Oh, okay, we'll give them 1%, and then of course they can retire then after that lawsuit.
Judge, you brought up the jury a couple of times, and I would love to get your perspective. You've spoken to more jurors than certainly anybody in this room, maybe anybody in California.
Actually, I don't talk to many jurors.
Well, but you met them.
Yeah, of course. Yes, I see them in court. Yes.
And could you maybe give a perspective on how capable or
very capable, very capable. I think that I'm going to explain Can I give a 2-minute speech?
Please.
Our third branch of government, the judiciary, is not elected. We are appointed for life. It's about the most undemocratic branch of government we have. The president is elected, the Congress is elected, the judges are appointed for life and never elected on the federal side. And yet, in every single poll since 1942, whenever they started, the judiciary, federal judiciary, is near the top of the institutions that the public respects. And the Congress is down there with the HMOs. How can that be? Well, here's the reason. The people come into our court as jurors, or they sit there in the audience watching the press. But it's, juror after juror comes in, even the potential ones, and they see how fair the process is. I've got hundreds of letters of how fair the process is from jurors. And they then say, we respect this. There's no politics. They come in and they see that there is no politics, unlike the other two branches of government where everything is politics. The ordinary citizen could go to Congress. Do you think they would get a fair hearing? Really? No, they would not get it. They couldn't even get in the door. Unless what? Unless they gave a lot of money to somebody. That's just the way it works. But with there's no money. Nobody brings me a bag of money. Nobody brings a juror a bag of money. It is done on the merits, and America loves the idea that something left in our world is still done on the merits.
It still works. Not perfectly, not all the time, but it still works.
There are no politics.
We have just a few more minutes left, Judge. I want to ask you two questions before we have to stop. One, again, keeping with the theme of intellectual property and why many of us are here today. Is there any one area of the IP law, define it as broadly as you would like, that particularly needs fixing, that based on your experience sitting on all these cases for all these years, needs to be addressed?
Yes, damages. I could give you a couple more, but damages should be greatly restricted to the true value of what this little invention, assuming it's valid, what contribution it made to the infringing product on the patent side. And the lawyers, it's probably true in copyright too, they come up with these theories of but mainly it's patent. Mainly it's patent where the lawyer is good at making it sound like this is the single. They don't realize there have been millions of patents, and it's this kind of look at that red ribbon, and it's worth 1% of the iPhone. Damages should be restricted. I've had some ideas over the years, but nobody likes my ideas. I had one idea was this. Okay, you patent owner who invented this thing, lying in bed from 5 to 7 a.m. thinking. You have no real hard outlay of money. You did no R&D. You just thought, okay, this still could be a patent, could be a valid patent. But the question is, okay, how much money did you invest in inventing this, coming up with this invention? So let's say it's $1,000 or $10,000. Okay, that ought to be the base from which a reasonable royalty would be calculated. It should be $1,000 times whatever it would take over X years of the patent to compensate them for the plus enough to reward innovation. That would be a small fraction of what they're asking for today. But they, at least the last time I looked at the patent law, the Federal Circuit has not. The Federal Circuit did for a while have this rule about you have to limit it to the contribution made by this. Yes, they did, but it's still they continued with the same old 1% theory. So no. I think there needs to be a more hard and fast way to cabin damages. That's I'll just stop there.
Can I ask, is there a part of the IP law that you've seen that you believe works particularly well, that has served its purposes and struck the right balance?
I think copyright law is does a good job. I think copyright law is done a pretty good job. Trademark law has done a pretty good job. I think it's the patent area with so many bad patents, and combined with damages. And the other thing I would change is the patent should not be presumed valid, and can only be overturned with clear and convincing evidence. It ought to be, it's not presumed valid, and only presumed valid, but ordinary preponderance of the evidence.
One or the other.
Yeah, but they didn't like that. The Federal Circuit didn't like that. I said that in one, they reversed that too. So there we go.
Well, let me ask you to close. What are you going to miss most about life at the court, Judge?
Oral arguments, trials, and oral arguments. Here's a little thing that some of you younger lawyers might need to remember. There are two kinds of judges. Some like to learn by reading, and some like to learn by listening. I'm in the listening category. I'm a slow reader. It takes me forever to get through a brief. But if I go into the courtroom and we start having the back and forth, I learn 3 times as much in 10 minutes as I'm going to learn in an hour reading the brief. So I like oral arguments. I learn a lot to kind of get it down to what the nub of the problem is. But there are other judges, and I could name some, but I won't because it's a trade secret, who would much prefer to skip oral arguments and decide everything on the papers. And so I'm going to miss oral arguments. I'm going to miss trials. I'm going to miss my law clerks. I'm going to miss the good lawyers. Good lawyers I was an okay lawyer. But when I see a good lawyer perform, it's, like the movie stars come into the courtroom and they're just brilliant. I'll miss all the good parts about the job.
Well, what a privilege it is to see great lawyers in action. What a privilege it is to call you a colleague and friend for all these years. Thank you on behalf of all of us. Thank you on behalf of the bar. And join me all, please. And thank you. Interrogator's prerogative. Bonus last question.
Sure.
What's next? What are you going to do with all this free time?
Clean out the basement.
All right, we'll leave it there.